Still watching Acfim Talks, and welcome back from the break. Acfim Talks is brought to you by Alliance for Finance Monitoring, the political finance watchdog in Africa. And we're still discussing what lessons can we draw from Kenya, given the way they have managed the electoral process, adjudicating on the electoral matters. There was a petition contesting the results, and it was dispensed, and we have a president-elect. Come next week, we'll be having the 5th president of Kenya, Dr. Ruto. It's been a very interesting journey for Kenya, and does talk so much about the journey Kenya's democracy has taken. There's much to learn from as a country. Remember, we are, as democracy, we keep growing, we keep learning, and every country is at its different stage. But the most important thing is that we learn from others who have gone ahead of us. Before I went for the break, Doctor had touched something that I feel I should bring in here. Charity, having observed the elections, but also having followed the proceedings in court. I want you to comment on how prepared the legal team representing the petitioner was, but also what did they get wrong to lose the case? Did they have a solid case? Leaving us from there, did they have any solid case? Because when you look at the arguments and the counter arguments, from your perspective, and as someone who is an expert in these matters, give us your opinions on this case.
Okay, so I was saying that the question was whether what was wrong with the legal team and whether they had a strong case or not, and what should they have done. And I think Daniel has been trying to explain the question of burden of proof. I'll come back to the question of burden of proof, but I felt I needed to underscore the fact that Uganda does not have a competent court. Dr. Daniel Ruheza said we have competent courts, and that in 2016 we sat before a competent court. For me, I feel that for us to get to the point of saying we have a competent court, that court should not supply us hot air, which we had in Kenya. Kenya talked about hot air being supplied from the people that we are supposed to prove the burden of proof. Now, even us, the court supplied Ugandans hot air in 2016 because they gave recommendations. They did not give court orders. They did not give injunctions. They did not use their power, which they have. If they had given court orders, right now the Attorney General would have been held in contempt of court. But guess what the court did? It simply gave recommendations. It means we can continue in that mode forever. They will always run away from pronouncing themselves, and they will make flimsy excuses of why they cannot put their foot down. If they were going to be a competent court, in my view, they should have issued orders. They should, because court has power to have prohibitive, prerogatory, punitive orders. So what we need is for them to exercise that power that is given to them constitutionally and to protect citizens. Because to promote democracy and to promote participation of the citizens, the court must always protect the rights of citizens. And in this instance of 2016, they did not protect our rights. And for that matter, they were not a competent court. Now, back to the legal team of Raila. Did they have a strong case? I only think Raila's team could have had a strong case if they had spent time to invest in technology. One, to assess whether during the time of uploading the form, there was a possibility of a third arm changing those forms. Two, to prove that by the time the forms were getting into the IEBC center or place, they had already been adulterated by a third party. Now they failed to prove that. Things of technology are extremely difficult to prove, except when you have highly technical people, because technology can be easily, you can have hackers. And it is possible that those forms could have even been changed if you have access. You see, there are layers of access. There are those who are encrypted, there are those who are not encrypted, there are those who have rights. But court does not decide cases on hearsay. Court decides cases on facts. So what the team of Raila did not do was to present facts. What they presented were issues, but beyond the issues, can you now prove beyond reasonable doubt? When they say prove beyond reasonable doubt, it means that even an ordinary person who sees can say, truly, there, you stole, you surely changed. But in this instance, even the ordinary people were saying, yeah, but when we looked at the server, the forms we see there are the very ones we see here. Even when they gave them the access to all the servers of IEBC, they told them, okay, produce for us only 2 or even 3 forms that have changed in character or anything, you know. The judges were trying to say, okay, nothing came out. Even the boxes they recounted, the results were the same. And also remember that the electoral observers had done PVT. Now, PVT is, they did a parallel voter tabulation. And in that PVT, still Ruto returned as the leader or the winner of this election. 3 observer groups all came out and said, look, according to our PVT, this is what we have. Now, if even the observers, this is what they are getting, IEBC, this is what it's getting, ordinary Kenyans who have tallied for themselves, they still got Ruto. So now, what was Raila's team going to prove? I had hoped that they had information because they had agents across all their polling stations. When you have agents across polling stations and there are issues you've identified with the process of election, you take them down, but pick evidence. Always in presidential petitions, and this is a general rule, in presidential petitions, the burden of proof is extremely high. And Dr. Ruweza told you that in the Evidence Act, Section 101, he who alleges must prove by 100% you have the jurisdiction, that you have the testimony, that you have the evidence, that you have the proof. If you don't have proof, then you have no case. And this is exactly what Raila's team did. They had no proof. And for that matter, they needed to have prepared better, they needed to have thought through the process better, and they needed to have invested highly in the question of a technical team that understands hacking and changing of systems, online systems and technology.
Thank you so much, Charity. Councillor God, I know you'd want to weigh in on that one, but as you weigh in on that one, I also have a question for you regarding how, especially looking at the composition of the especially both teams, because when you look at both teams, you would find that in that court there were no less than 3 governors, I think, elected, 4 senators elected. There were also 4 MPs, all elected as members of the legal team on either sides. And anybody who is looking at this beyond just the composition of the legal teams on both parties, you see that it speaks a lot about the involvement of Kenya's intelligentsia in elective politics at different levels. And as Uganda, how can we encourage more of the members of Uganda's intelligentsia to participate in elective politics? Because we all know what happens when it comes back home here in our area of elective politics, how the intelligentsia seems to have detached itself from participating in that process. How do we encourage them to move back in the fold, participate in this process, and deliver quality democracy, not just democracy, but quality democracy?
Thank you very much, Felix. First of all, to react to whether the legal team of Raila Odinga was prepared or not, Felix, preparing for a presidential election petition is not an easy task. In fact, what legal teams normally do is that they start collecting evidence from the first day of campaigns. Because the nature of evidence that is required is one that requires you to file affidavits. You need people to swear these statements. But for you to be able to have credible evidence, it means that you need to have prepared yourself very well. And I was looking at how previous legal teams here in Uganda were preparing. They started collecting affidavits during campaigns, not after the election. That way, you have the opportunity to present a credible case in court. But again, getting to the issue of burden of proof, when it comes to presidential election matters, it is above a balance of probabilities, meaning that it's above the standard in civil cases, but also it is not to the standard in criminal matters, which is beyond reasonable doubt. And that is where I have an issue with our Supreme Courts, because they have tended to treat presidential election petitions as though they are trials, normal trials. Because these are presidential election petitions, not a normal trial whereby you have to follow the rules very strictly. But again, that leads me to two legal principles, and that is judicial restraint vis-a-vis judicial activism. Under judicial restraint, that is where you find most judicial officers doing their best to avoid questions of a political nature. And in this case, for a presidential election petition, that's how you will see courts emphasizing so much about evidence. But when you look at the laws that govern presidential election petitions in these countries, you will find that there is some power that is given to the judiciary to inquire into the processes. In other words, you do not only rely on the evidence presented by the petitioner or respondent, but you also need to do your own independent inquiry as a judiciary so that you breathe life into the provisions of the Constitution, but also other laws that govern elections, including the presidential election. So for me, that treatment that our judiciaries have sometimes given to presidential election petitions is where I have an issue with. Of course, we've had some judicial activists in Kenya. For instance, that election petition that was annulled, it has the element of judicial activism. But now, when you look at people that believe in judicial restraint, they tend to look at the future of the country after that election petition is either accepted or refused. Thank you.
Thank you so much, Council Court. Doctor, let me bring you in here. Did I lose Doctor? Okay, I think I lost Doctor in the process. Charity, are you there? Okay, I don't seem to be having Charity. Council Court, as the two get back on set.
Yeah.
The issue of the intelligentsia, you saw
Yes.
you saw the composition of both teams. You had
Yes.
their elected MPs.
You see,
back home here, the intelligentsia seems to be steering clear of being part of elective politics. What is it that we can do to encourage the Uganda's intelligentsia, all so-called elites participate in elective politics, and don't leave it to individuals, people we tend to look at as not necessarily elite or not necessarily the intelligent category, to lead us in the politics we want to see.
Felix.
Felix, if you would allow me, before you get into the second question to my brother or court, George, allow me to just respond to, I think, what Charity had said regarding competence of the courts. I think I just wanted to guide that, you know, when you're dealing with competence, you're looking really at the rules of which come to jurisdiction. Do you have the power to adjudicate? Does the Constitution give you the power? And do you have the power to be able to adjudicate over an issue? If a magistrate court was adjudicating over a presidential petition, we would then say that that magistrate court does not have the competence to do so. We could disagree with the final decision of that Supreme Court, but if they tick the boxes on competence, that the people who are there have got the requisite qualifications and experience, we may not agree with, say, their previous work backgrounds, but do they tick the box? That is what I mean by competence. And also, when you see what happened with the Supreme Court decision of Uganda in 2016, they issued what we call structural interdicts. Structural interdicts are actually orders of the court, and they were requiring the person or the office of the Attorney General to implement certain things. So the court actually this time went beyond mere recommendations, because the idea behind the amicus curiae application was to say, look, for the different times that matters regarding the elections have come before you, you have given recommendations, but recommendations have not been implemented. So what we are asking of you today, don't just give a recommendation, give a structural interdict, give an order requiring the Attorney General to do something and come back and report. So the Attorney General was specifically given certain instructions to do certain things. So the orders of the court were there. Indeed, that is why Kituo cha Katiba, Professor Sempebwa, and Professor Juko, after the 2-year limit that had been given to the Attorney General, went back and told the court that, look, the orders you gave have not been done, have not been implemented by the Attorney General. Can you please find the Attorney General in contempt of your order? And then the Attorney General had to give a response as to whether or not they had complied with the orders of the court. And I think that was a good advancement to our mere recommendations in that regard. I think George has spoken about the standard of proof versus the burden of proof. And maybe I just want to say that probably we need to go back to the court, and the court helps us appreciate, what does the Supreme Court do? Does the Supreme Court carry out a trial, or it carries out an inquiry? Because some of the lawyers have argued that we need an inquiry. Go beyond just sitting back and listening to receive evidence, and sit as an inquisitor to find out whether the process was done right. The judicial activists are saying, let us have an inquiry by the court, although the court to this extent has not yet agreed with them. And so maybe we need to either go back to Parliament and ask Parliament to review those words. Did Parliament want an inquiry, or did Parliament want a trial? That would help us to be able to finally sort it out. If it's an inquiry, then probably we even need to give the courts slightly more time to inquire into the election, basically to receive more than just the evidence by affidavits. Although now, even if you swear an affidavit before our courts, you can be called in and cross-examined on it. That is what I wanted to just clarify or to respond to the observations that have been made by my sister Charity. Thank you.
Thank you so much, Dr. Daniel Rohoiza. Council Court, back to you quickly because our time is fast spent.
Yes. Felix, yes. I know where you want us to lead on this one, but just to let you know that politics in Kenya pays a lot. People earn a lot of money, most especially the likes of the governors, MPs, they're earning a lot of money. So there is a serious incentive for even you, the elite, to go and participate in the politics of that country. So when you see the kind of politicians that we have here and those that we have in Kenya, still you'll realize that there is that aspect of money incentivizing their participation. But again, I think the elites here still have that fear of political competition. You will find that most of the people that contest here in Uganda are senior six dropouts. Most of them may have nothing to lose by contesting in an election. But you, Felix, and I, because we have a small office to protect here at Acfim, you feel you need to protect that as opposed to going to serve your country. That is what I would say briefly about it.
Okay, Charity, you're going to have the last word on this one. Just one question, a follow-up on that one. And I think we've had this discussion before, Charity. Why is the Uganda's intelligentsia steering clear of participating in elective politics? That is one. Just your thoughts on that one, but also your thoughts on the fact that if you look at Kenya, for example, almost at every stage of the electoral cycle, you see the work petitions, and you see the court dispensing these petitions within the time. Yet when it comes back to Uganda here, you have petitions that drag on and drag on, and you know justice delayed is justice denied. What can we learn from that quickly as we wrap up?
So I think that Kenya demonstrated to us that democracy can work as long as there is transparency in every process. I think the most important thing is to understand transparency in every process within the electoral cycle, including in the courts, because the courts themselves were also very transparent in their processes. There was nowhere at any one time, even when Kome said, my team has retired to write, people said, she has gone to a secret place to write. Then they said, yes, but she has gone to write what we have been hearing and what we have known. So there was nothing like anything was hidden, and there was information that was being kept away from the people. So it is very important that when it comes to issues of the people, as provided in Article 1 of our Constitution and runs through up to the judiciary in 126, that the judiciary will serve the people of Uganda. Everything they do should be for the people. Then transparency is a critical tenet that must be adopted. Now, when you ask about the intelligentsia, they fall in the category of they have been de-alienated from processes. If you go at Makerere University, for example, if you're an open thinker, if you're a person who is objective on many of these issues, they have choked those voices. They have thrown out professors. Professor Ndebesa is no longer there. There are many professors who have been frustrated because they came out to speak about processes. And so their friends are watching and saying, if they threw out my friend, what is the possibility that I will not be going? Most of them have chosen to go under the table Those who have not gone under the table are talking on they are working on a thin thread. And so we need to improve our processes to allow for citizens to interact with the governance of their country as provided in Article 38 of the Constitution. Ugandan intellectuals who went and applied to Electoral Commission to observe the 2021 election were denied accreditation by the same commission. In Kenya, whoever wanted accreditation was cleared. There were over 150 observer groups. Can you imagine that? And in Uganda, they were selecting. These ones will talk well, these won't talk well, these ones will do this. Just let the process be. Let people be involved in their processes, and you will see democracy work better for everyone. Thank you,
so
Felix.
much. Thank you so much, Charity.
Felix, a sentence to supplement?
Yeah, we are wrapping up. Make it short, please.
Just a sentence to add to what Charity has said. The 2010 constitution in Kenya created a new dimension to make it possible for some of these things to happen. And therefore, we need to start thinking in that same direction. Thank you very much.
Thank you so much. I'm sorry, I'm going to bring this to a close. A very interesting discussion, but we can continue with this conversation on our social media platforms. We were discussing Kenya's presidential elections and what is the place of judiciary in the African democratization process. With me, I had Dr. Daniel Roweza, who is a law donor at Makerere University, well-versed with constitutional law, international law, treaty law, and law of evidence. He's also the adjunct professor at Uganda Military Academy, Kabamba. I also had with me Charity Hibisibwe, who is the electoral democracy expert, did participate and observe those elections. He's also the current executive director at the Electoral Law Institute, also the former executive director of CEDU, commonly, that is Citizen Coalition for Electoral Democracy in Uganda. And lastly, I had Counsel Robert Okot, who is an advocate of the High Court, a member of the Uganda Law Society, East African Law Society, and also NETPIL, which is a network of public interest lawyers. He's done a lot around non-profit law and also political finance regulation, which was interestingly one of the key issues that was petitioned. I think it was petitioned during the last just concluded elections in Kenya. It's been a very interesting conversation. And till next time, same place. Bye-bye. Remain your host, Felix Kafuma. Take care. Have a nice week.